Welcome to the deep dive. Today, we're getting into something foundational. The preliminary title of Argentina's Civil and Commercial Code.
Yeah, it's like the cornerstone, really. Sets
Yeah.
the tone for almost everything else in their private law.
Exactly. We've gone through the sources, and what we want to do is unpack this, give you the essentials of how it works and why it actually matters.
It's the instruction manual, basically.
Hmm.
Understanding this helps make sense of the whole system.
Right. And look, whether you do business in Argentina, you're just interested in legal systems or how societies work, this stuff offers some genuine insights. We're aiming for the practical takeaways here.
It really does show you the core values and the logic driving Argentinian law.
Okay, so the plan. We'll start with a hierarchy of legal sources. Where does the law come from? Then how is it interpreted? We'll touch on key ideas like good faith, avoiding abuse of rights, and then see how it all connects.
Sounds good. Article 1 is the place to start, then, with that hierarchy.
So what's at the very top?
That's what they call the constitutional block. So the Argentinian Constitution itself, and crucially, human rights treaties that have constitutional status.
Meaning they carry the same weight.
Exactly. No law can contradict them. They're the supreme law.
Okay. And what's below that level?
Then you get other international treaties Argentina is part of, followed by national laws that includes this civil and commercial code we're discussing and, other laws passed by Congress.
Right.
And then, interestingly, you have uses, practices, and customs.
Customs, how exactly do they fit in? Are they actual law?
Well, they apply only when the law specifically points to them or if there's a gap in the law, provided they don't contradict the law itself. It's not a free-for-all.
Okay.
And this whole thing operates through what's called the dialogue of sources. Judges need to look at this whole picture and apply the rule that fits best. It's dynamic.
So not just a rigid list. What about court decisions? Precedent.
Interestingly, the code doesn't explicitly name jurisprudence, past court rulings, as a formal source.
Right.
Yeah, but, in practice, of course, judges look at how similar cases were decided. It has undeniable weight, just not listed in Article 1.
Got it. So Constitution and human rights up top, then treaties, laws, and sometimes customs. Now, how do judges figure out what these laws mean? That brings us to Article 2, interpretation.
Right, and it's clear. You can't just stick to the literal words on the page.
Okay, so what else do they look at?
They have to consider the law's purpose, what was it trying to achieve, also analogous laws, other similar rules. And again, those human rights treaties are mandatory guides, plus general legal principles and values.
So it's a whole toolkit for interpretation.
Exactly. They use different methods, grammatical, logical, teleological, that's the purpose one, systematic, how it fits with everything else, sometimes even historical context. The key is consistency with the entire legal order.
Makes sense. It has to fit together. Now, Article 3, the duty to resolve. Judges have to make a call.
Absolutely.
Yeah.
If a case is properly before them, they must decide it. No ducking the issue. And the decision has to be reasonably founded, meaning based on law and logic, not just arbitrary. It's part of the right to effective justice.
Okay. And who do these laws apply to? Article 4.
Broadly, everyone living in Argentina, citizen or not. The principle is territoriality.
And you can't claim you just didn't know the law?
Generally, no. Ignorance of the law is no excuse. That's a classic legal principle. There's a small note about special laws maybe being different, but that's the main rule.
And when does a law start being a law? Article 5.
Usually 8 days after it's published in the official gazette. That's the default.
But it can be different?
Yes, the law itself can specify a different start date, but that official publication is key. That's when it becomes binding.
Okay. Article 6 is about calculating deadlines. Seems technical, but important.
Very important, yeah. Deadlines are usually counted in continuous calendar days, weekends, holidays, all included, unless the law says otherwise. Huge practical impact.
Right. Now, Article 7, applying laws over time. This can get tricky, right? When a law changes.
It can. The general rule is that new laws apply immediately to the future consequences of existing situations.
But not backward.
Generally, no retroactivity. Laws don't rewrite the past. But there's a big exception for consumer law.
Oh.
If a new law is more favorable to the consumer, it applies immediately, even to contracts or situations already ongoing.
That's a strong protection. Okay, let's shift to Articles 9 and 10, good faith and abuse of rights. These sound fundamental.
They absolutely are. Good faith acting honestly and fairly is a core principle for how you exercise your rights and how laws are interpreted.
Okay.
It also includes the idea you can't contradict your own past behavior if someone reasonably relied on it, the doctrine of own acts.
And abuse of rights. So you can follow the letter of the law but still be wrong.
Precisely. Article 10 says exercising a right becomes abusive if it goes against the law's purpose or against good faith, morality, or good customs. Even if technically legal, it's not allowed if it's abusive.
And what happens then?
A judge can stop the abusive action or order compensation for any harm caused. It shows the spirit of the law matters just as much as the text.
So these ideas, good faith, no abuse, they weave through everything, like contracts, property.
Definitely. Good faith is vital in negotiating contracts. You can't use your property rights in a way that's purely designed to harm your neighbor that could be abusive. These principles from the preliminary title pop up everywhere.
So wrapping up, this preliminary title isn't just abstract legal stuff. It's really the operating system, the core logic for Argentinian private law.
Exactly. Understanding these first few articles gives you a powerful lens to see how the whole system works.
So here's something to think about. Given how central human rights and preventing abusive rights are in Articles 2 and 10, how might these principles adapt or be applied to totally new challenges? Think AI, complex environmental issues, things like that. This framework provides stability, but maybe it also holds the keys for future legal evolution in Argentina.